Heyo, folks! An impromptu stream because a bit under the radar, but I've seen this case before and been waiting to hear the result of the Fifth Circuit Appellate Court decision. It is about this guy is an real. It is local Texas prosecutor Ralph Petty Jr., who for 20 years double-timed as both a prosecutor and a law clerk. Sometimes he was a law clerk for judges he presented cases for as a prosecutor. That is, Judge Glanville, this guy. This also, for you who follow the Young Thug trial, gives you an understanding how hard it is and what level you need to reach before a prosecutor gets punished, and how many victims this particular prosecutor might have. It took 20 years before he was discovered doing this. 20 years, folks. He was both a prosecutor and a law clerk for different judges. It is mind-blowing. Absolutely mind-blowing. And let's start with an article, so you get a hang of it. This is from Reason. The paper is actually called Reason. This prosecutor secretly worked for the judges overseeing his cases. Will his victims be able to sue? Ralph Petty likely violated the Constitution. In a rare move, a federal court signaled this week that lawsuits against him may not be dead on arrival. This is from February 16th of this year. And that is former prosecutor Ralph Petty. And this article keeps going with, there's an inverse relationship between the shock value in Irma Wilson's criminal justice experience and the remedy, or lack thereof, afforded to her from an alleged violation of her constitutional rights. Despite the federal judge calling her story utterly bonkers, she had been barred from going before a jury and stating her civil case against the rogue ex-prosecutor. In a rare turn, that might finally change. The U.S. Court of Appeals for the Fifth Circuit this week agreed to rehear her petition, implying a majority of judges may be inclined to reverse the court's previous ruling, which shielded from liability this ass who allegedly helped prosecute Wilson while he covertly worked for the same judges overseeing his cases. In 2001, the Midland County District Attorney promoted Ralph Petty Jr. from law clerk to prosecutor, but instead of transitioning to his new role, he kept both, simultaneously prosecuting cases and assisting judges as the right-hand man. That means by day, Petty, like any prosecutor, pursued rulings vindicating the government, and then at night, he would draft the very rulings he sought. And this is not only on this assistant district attorney, because these judges knew and let it happen. They let this happen for 20 years. Hey, Casper, the judges didn't know? Of course they knew. He was the prosecutor, and then he helped them draft rulings for the same judges for 20 years. That year, Wilson found herself in the same courthouse. Police arrested her after finding some crack cocaine on the ground near where she and some friends were standing. She vehemently denied it was hers, and law enforcement informed her she could go free if she told them whom it belonged to. She said she didn't know. The government attempted to avoid a trial, offering Wilson several plea deals. She declined all of them, insisting on both her innocence and a trial by jury, the latter of which is vanishingly rare in the modern criminal justice system. She was convicted and sentenced to 8 years of community supervision, but Wilson's punishment has subsided to this day in that her conviction precluded her from becoming a nurse. Her dream since childhood, because Texas forbids people convicted of drug-related offenses from obtaining a nursing license. Yeah, she stood near where they found crack cocaine. She and others stood near. And the Texas jury found her guilty. They offered her plea after plea after plea. And then when she wouldn't take it, I assume her punishment were crooked prosecutors like this Wilson. Yeah, this Weldon asshat chose to punish her for it. Yeah, this makes, yeah. Petty's dual hat shenanigans lasted from 2001 to 2014 and again from 2017 to 2018. It didn't come to light until the following year when Midland County District Attorney Laura Nodoff reviewed his accounting records and was confronted with the fact that hundreds of cases may have been tainted by his conflict of interest. Fortunately for Petty, the timing of that discovery coincided with his retirement. He was ultimately disbarred in 2021, 2 years after he left his post. Yeah. So that absolute waste of air is probably still living off a government pension after screwing with victims and defendants for almost 20 years. It's an extremely difficult task to achieve any remedy when a prosecutor violates the Constitution, as the role is typically preceded by absolute immunity. After Petty's misconduct came to light, Wilson tried anyway via a lawsuit that alleges Petty infringed her 14th Amendment rights by moonlighting for then-Judge John G. Hyde, who adjudicated her case. Hyde passed away in 2012. Burn in hell, you crooked judge. But then Wilson sued under paragraph 1983, the relevant civil rights statute. The client died before a court could evaluate whether Petty was entitled to absolute immunity, thanks to yet another barrier placed before similarly situated alleged victims of government abuse. Quote, a convicted party cannot seek damages for unconstitutional conviction or imprisonment without first showing that the conviction or sentence has been reversed on appeal or otherwise declared invalid. This was Fifth Circuit in December, which was a majority decision on a minority of the judges that the Fifth Circuit consists of. So what happened then? Well, this made since it was just a majority decision, there was a chance that if they called in the entire, all the judges for the appellate court, there might be a different result. And the ruling came in September 13. And sadly, it was yet again a majority decision. But the dissidents to this majority decision were scathing against the majority. For you who don't know about this absolute immunity or the prosecutorial immunity, that is a reality for all prosecutors and judges. Absolute immunity is not a law. This is something the courts themselves have made up a long time ago, because there were a lot of cases where they were sued and had to spend money on protecting themselves against lawsuits. So they made up this new rule that they have immunity for misconduct or alleged misconduct. Now, for the past 40-something years, this has become what we see today. In the Young Thug trial, in this case, it protects corrupt prosecutors and bad judges. They can, as we've seen in the Young Thug case, Miss Love can lie to the court over and over and over again, and more or less nothing happens. She can send people to prison knowing there's a high chance they will die. She can send people to jail knowing there's a high risk they might die in jail. And she does it anyway. And in the Shane Kendall case, she can't even be on the lawsuit because she has this not a good time to be sarcastic, so please avoid it. Not a good time. Not this one. Not this one. There are death penalty cases, this asshat. There are people dying because of him. So not a good time. Not a good time. If you don't know Ken's counseling coach, I love him. His sarcasm is amazing. Not a good time this time. So let's move on to the dissident decision. Now, when there's only a majority decision in the Fifth Circuit, this case is probably headed to the Supreme Court. So let's make this bigger. Don R. Willett, Circuit Judge, joined by King, Elrod, Graves, Higginson, and Douglas, Circuit Judges dissenting. They start with a fair trial in a fair tribunal is basic requirement of due process. The Constitution's fair trial requirement is Con Law 101, a bedrock due process guarantee. In fact, the framers cared so much about the sanctity of the criminal jury trial that our Constitution specifically mentions it twice, not only in the Sixth Amendment, but also in Article 3. And to underscore they really meant it, that criminal justice fairness is sacrosanct, the funding generation doubled down enshrining a host of procedural non-negotiables in multiple provisions of the Bill of Rights. Indeed, more words are devoted to "we the people" fair trial right than to any other constitutional guarantee. Safe to say, the framers were fixated on the adjudication of criminal charges, both the power to bring them and the process for resolving them, and spilled a lot of ink to ensure that the Constitution's inviolable fair trial guarantee is no empty promise. Yeah, I'm beyond pissed off with this. Beyond pissed off that there actually are judges who wants to I assume it is because many wants to keep the absolute immunity for prosecutors and for judges. But when it goes this far, they risk that the Supreme Court, the SCOTUS, will remove most of those protections, because there are so many corrupt prosecutors out there that do not deserve protection. They do not deserve it. And this case is so over the top. I can't even joke about it. I can't even joke about this. During our second founding, almost a century later, Congress, besides passing the 14th Amendment, also acted statutorily with a sweeping textual command in the Civil Rights Act of 1871 that rights violators, quote, shall be liable to the party injured. These lofty words, however, are just that, pretty parchment promises, if the judicial fine print of made-up caveats, exceptions, and qualifiers ensures that abuses and abusers get a pass even for the most egregious, conscience-shocking deprivation. It took Irma Wilson 20 years to learn of the brazen prosecutorial misconduct that laid waste to her fundamental fair trial right. Long after she had been convicted, lost her direct appeal, and served her suspended sentence. The stunning revelation came to light in 2021 when USA Today broke the story of a Texas death row inmate, Clinton Lee Young, whose prosecutor, Weldon Ralph Petty Jr., had been moonlighting as a paid law clerk to the judge overseeing Lee's capital trial. Turns out Prosecutor Petty had been clerking for multiple Midland County judges for almost 2 decades, seeking favorable rulings in judges' public courtrooms by day and surreptitiously drafting those rulings in judges' private chambers by night. This was a DEFCON 1 legal scandal. A prosecutor being on the judge's payroll, and Wilson learned of Petty dual-hat arrangement along with the rest of the nation. But for her, it was personal. Petty had been working both sides of the bench during her prosecution. Wilson responded to the belated revelation by suing for damages under 42 U.S.C. 1983, alleging that Petty's covert side hustle, acting as both accuser and de facto adjudicator, flattened her due process right under the 14th Amendment. The district court dismissed Wilson's claim based on Heck v. Humphrey, a 1994 Supreme Court case in which the plaintiff prisoner brought a 1983 damages suit analogous to a malicious prosecution's claim. In Heck, the court famously and unanimously established a favorable termination rule. A state inmate's 1983 suit is not cognizable unless the inmate first shows a favorable termination to his criminal conviction or confinement. However, the court splintered 5-4 over the rule's reach and rigidity. Today's en banc case poses one and only one question. Does Heck v. Humphrey favorable termination rule apply to non-custodial plaintiffs? This question has been hotly debated in the lower courts since Heck was decided 3 decades ago. Footnoted dicta and vehement concurrences from various Supreme Court justices over the years have played starring roles. The unsurprising upshot is a deep and enduring circuit split. Indeed, we are the second circuit to take the issue en banc in recent years. The case in review is, hold on, USDC number 7-22 CV15. Hold on. I was at 37. My take. This is the writer of this dissident. The majority opinion in Heck had no reason to address whether the rule applied to plaintiffs who have already completed their sentences, because the plaintiff in Heck was still in prison. But in infamous footnote 10, the very quintessence of dicta, the court mused that the favorable termination requirement should also reach plaintiffs who are no longer incarcerated. The Supreme Court's later admonition in District of Columbia v. Heller about latching onto unargued, unbriefed, unconsidered pronouncements have never rung more true. Quote, "It is inconceivable that we would rest our interpretation upon such a footnoted dictum in a case where the point was not at issue and was not argued." Justice Sauter's Heck's concurrence, joined by 3 of his colleagues, took dead aim at footnote 10. He remarked that non-custodial plaintiffs should not have to prove favorable termination because they fall, quote, outside the intersection of paragraph 1983 and the habeas statute. And the majority's view, quote, would be to deny any federal forum to plaintiffs who could not possibly obtain favorable termination through federal habeas because the federal habeas statute requires an individual to be in custody to file a claim. 4 years later, the justices continued their debate in concurrences and a dissident in Spencer v. Kemner, where Justice Ginsburg, who had joined the majority in Heck, wrote that she had thought better of it. Quote, "Individuals without recourse to the habeas statute because they are not in custody fit within 1983's broad reach." These opinions have teed up spirited lower courts debates over whether Heck reaches non-custodial plaintiffs. And notably, the Supreme Court, in its own words, has yet to, quote, settle the issue. As for our circuit, we held in 2020 that non-custodial plaintiffs must show favorable termination in a sparsely reasoned per curiam opinion that was barely over 2 pages long. In taking this case en banc, we had an opportunity to correct that flawed precedent. Regrettably, we have squandered that opportunity. Hello, folks, by the way. Hello. There are a bunch of you here for a Saturday night. Decent numbers. Thank you for being here. Thank you for being here. With boundless respect for my eminent colleagues, their plurality has disfigured Heck to impose a favorable termination requirement as an, quote, element for, quote, all 1983 claims by all civil plaintiffs who seek civil remedies against defective criminal process. This holding is doubly violative. Americans robbed of their constitutional rights are also robbed of any federal forum to vindicate those rights. I respectfully dissent. That would hold that Heck's favorable termination rule applies only to custodial 1983 plaintiffs. To set the stage for explaining how the plurality goes awry, I'll first discuss the, quote, two most fertile sources of federal court prisoner litigation. This case, which lie at the core of the dispute. Notably, both statutes, quote, provide access to a federal forum for claims of unconstitutional treatment at the hands of state officials, but they differ in their scope and operation. Next, I'll walk through the pre-Heck cases that explore the overlap over the two statutes. The pre-Heck landscape shows that the court was deeply concerned with litigation at the intersection. In fact, the court had been engaged in a years-long project to delimit their respective scopes. And contrary to plurality's assertion, the court maintained this concern in Heck itself. A full understanding of both the statutes and the case law will inform how Heck should be rightly read. And let's see here. Yes, I heard about Gaither getting information from her nephew. She was married to the uncle of Zachary. I know that. I also know about the incarceration yesterday, which is infuriating. I will take it up on Monday during Monday because we don't know when little D will take the stand. Hopefully he has gotten himself representation by then. Let's see here. Here is Quindarius Zachary's fundraiser. Here's the link for that one. So if you want to contribute to Quindarius Zachary, so he can get representation, then that's the page to do that. They are almost $5,000 raised so far, but they need up towards 25 grand in order for him to actually retain somebody who can actually do some good work. But it's pinned on the top of the chat. Let's continue. Section 2254 is the federal habeas corpus statute. Habeas has deep roots in our nation's history and traditionally has been accepted as the specific instrument to obtain release from unlawful confinement or to deliver someone from unlawful custody. While habeas corpus is a powerful device for safeguarding individual freedom against arbitrary and lawless state action, in its codified modern form, federal habeas involves a formidable thicket of doctrines. And importantly, it requires prisoners to exhaust state remedies before seeking federal habeas relief. Some people, before being granted habeas corpus, might be in prison for decades. Not so with paragraph 1983. Written in sweeping terms against a backdrop of horrific violence, terror, and subjugation, this statute of constitutional accountability was meant to open courthouse doors, not bolt them shut. Unlike 2254, 1983 is worded quite open-endedly, providing a broad cause of action to, quote, every person who is subject to a deprivation of their rights, privileges, or immunities secured by the Constitution and laws. Its language is unsubtle and categorical, seemingly erasing any need for unwritten gap-filling implications, importations, and incorporations. Section 1983 was passed as a part of the Civil Rights Act of 1871, which was the congressional response to widespread lawlessness in the southern states and the inability and unwillingness of state and local officials to curb it. Importantly, it was because Congress lacked confidence in state institutions, including state courts, that it explicitly gave federal courts jurisdiction over the new civil action. The Reconstruction era was a sea change in terms of federal court access to redress constitutional violations. From the Judiciary Act of 1789 on, access to the lower federal courts had been largely restricted to citizens exposed to the possible prejudices of tribunals of foreign states. The prevailing assumption had been that the state courts were the appropriate forum for the enforcement of federal law. But with the passage of transformative new civil action, Congress gave 1983 plaintiffs a direct path to a federal court that did not require the exhaustion of state remedies first. In doing so, Congress put federal courts between states and their citizens, and it did so on purpose. Because Rule 1983 lacks an exhaustion requirement, prisoners have an understandable impulse to find a way out of habeas and into paragraph 1983. Partially driven by this reality, before Heck, the court had already begun to delineate the scopes. Early in that project, the court in Cooper v. Pate blessed the use of 1983 for state prisoners challenging the conditions of their confinement. A few years later, Fraser v. Rodriguez presented a tougher question: whether prisoners could use this paragraph instead of habeas to obtain an injunction to restore their good time credits and thus obtain earlier or immediate release from prison. If the prisoner succeeded, the judgment would require they be released sooner. This was problematic because habeas corpus was the traditional way prisoners could obtain release from prison. The court thought that even though the prisoners, quote, came within the literal terms of the paragraph, the broad text was not conclusive, or whether the prisoners could proceed via the paragraph, because the federal habeas corpus statute is specific and 1983 is general. The court held that Congress had determined that habeas is the appropriate remedy for state prisoners attacking the validity of the fact or length of their confinement. In the next case, this is a history lesson, by the way, folks. This is a history lesson on how they came to where we are today. In the next case, Wolf v. McDonald, prisoners challenged the validity of the procedures used to deny their good time credits and sought damages through the paragraph, because the claim was, quote, for using the wrong procedures, not for reaching the wrong result, and it did not call into question the lawfulness of the prisoner's continuing confinement. The court determined that the 1983 damages claim could proceed. It may already be apparent from this brief recounting that in all these cases, the court was intensely focused on whether a prisoner's claim called into question the lawfulness of his or her conviction or confinement, and would thus necessitate release from prison either earlier or immediately. If so, a prisoner could not seek damages, but if not, a prisoner could seek damages. The reason for this is clear. A challenge that would imply the invalidity of a prisoner's conviction or confinement, quote, is just as close to the core of habeas corpus as an attack on the prisoner's conviction, for it goes directly to the constitutionality of his physical confinement itself and seeks either immediate release from that confinement or shortening of its duration. Hi, Dark Horse Production. I reside in Sweden. These cases also share another feature. They all involve challenges from prisoners. The only reason the court got into the business of defining the respective scopes of paragraph 2254 and 1983 in the first place is because of their overlap, as both statutes provide access to a federal forum for claims of unconstitutional treatment at the hands of state official. Respectfully, the plurality misses both of these points. It claims that it is wrong to think that this entire area of law is predicated on such a collision between the two statutes. But a careful reading of the pre-Heck cases demonstrates that the court was focused on specifying when a prisoner could and couldn't choose the 1983 one, and its reasoning always involved the overlap between the statutes. Habeas is the elephant in the room whenever the scope of 1983 is at issue, because 1983, absent carefully specified limits, could sideline the federal habeas statute. But to say that some limits on 1983 are necessary because the specific controls the general is not to establish the validity of the plurality's proposed limitation. And the justification and the plurality's limitation is wanting. It is not based on conflict with another statute. It is seemingly based on protecting a set of values, comity, finality, etc., that for 153 years now, paragraph 1983 has always opposed, and intentionally so. Of course, none of these cases discussed above answer the questions teed up in Heck. Whether a prisoner who does not seek immediate or speedy release but monetary damages may bring damages claim when a successful civil action would, in reality, attack the validity of the prisoner's conviction or confinement. The plurality today asserts that the Heck court held that, quote, favorable termination is itself an element of any 1983 claim that seek money damages for a tainted conviction. But Heck's holding was far more limited. It applies only to prisoners whose claims are closely analogous to malicious prosecution. This is evident because, 1, Heck was limited to addressing whether prisoners could use this paragraph to challenge their convictions or confinement. The Heck opinion is framed in terms of the overlap between these two paragraphs, which indicates the court remained acutely concerned about the statute's respective scopes in Heck, and 3, tort law merely served as a starting point. In Heck, to determine the elements for the prisoner's plaintiff's specific claims, and it would make little sense to apply its holding more broadly. A telltale point about Heck: the word prisoner pervades the court's opinion. Roy Heck was in prison when he brought his claim. So the only question before the court involved custodial plaintiffs. In fact, the court's opinion opens with the unsubtle reference to Heck's custodial status. Quote, this case presents the question whether a state prisoner may challenge the constitutionality of his conviction in a suit for damages under 42 U.S.C. paragraph 1983. The court went on to say that it was applying a principle that concerns what actions are appropriate to challenge, quote, outstanding criminal judgment. It explained, and this is from this 42 U.S.C. 1983. We think my pronunciation might make this word sound different. The hoary principle that civil tort actions are not appropriate vehicles for challenging the validity of outstanding criminal judgments applies to the paragraph damages actions that necessarily require the plaintiffs to prove the unlawfulness of his conviction or confinement, just as it has always applied to actions for malicious prosecution. A judgment is a court or other tribunal's final determination of the rights and obligations of the parties in a case. And the word outstanding means unpaid, uncollected. It is only while a prisoner is still serving his sentence that it can be said to be outstanding. Once a prisoner has paid his debt to society by completing his sentence, the judgment is no longer outstanding. Thus, the use of the term outstanding criminal judgment indicates that the court's holding only applies to prisoners, those who have not yet fully served their sentences. This straightforward understanding of the court's holding aligns with the rest of the opinion. Immediately after stating its holding, the court explains the effect of its decision, again referring only to prisoners. Thus, when a state prisoner seeks damages in a 1983 suit, the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence. and if so, it must then determine whether favorable determination has been met. Given that Heck presented a question about prisoners, it is no surprise that the effect of the holding, as the court itself describes it, is limited to prisoners. Footnote 10 changes nothing. Footnote 10 statements that the, quote, principle barring collateral attacks is not rendered inapplicable by the fortitude that a convicted criminal is no longer incarcerated. Is the apex of the dicta, the unofficial opinion, so to speak. Stray musings about something that, quote, was not at issue and was not argued. Our president puts it this way, quote, a statement is dictum of it could have been deleted without seriously impairing the analytical foundations of the holding and being peripheral, may not have received the full and careful consideration of the court that uttered it. As Judge Easterbrook remarked about footnote 10, quote, a clearer example of dicta is hard to imagine, end quote, because the footnote concerns a subject that had not been briefed by the parties, that did not matter to the disposition of Heck's claim, and that the majority thought would not matter to anyone ever. So yeah, this footnote, what they are talking about here is this footnote could be removed and it would change nothing in the Heck opinion. It could be just thrown out and would change nothing about the judgment. But that footnote is one of the foundations of prosecutorial immunity. In this case, she can't sue him for being a corrupt prosecutor because of a footnote that has no bearing on the decision in Heck. But when prosecutors become judges all the time, that is what you get. How can I protect myself? And a judge, I used to be a prosecutor. I want to protect prosecutors. So they cling on to this footnote 10 like leeches on a leg, or flies to a pile of crap, when the footnote itself has no bearing on the decision in Heck. It's pissing me off here. I'm pissing myself off here. Indeed, it is worth emphasizing that in Heck itself, the court rejected an argument that it should rely on dicta from Pricer, because that opinion, quote, had no cause to address and did not carefully consider the damages question. Presented in Heck, precisely the same can be said of Heck's footnote 10. Hi, Yoda. I'm doing good. Thank you for asking. This case demonstrates why we do not rely on dicta. Quote, an unreliable, if not an unintelligible guide. The Heck court assumed wrongly that custodial status would not matter to anyone, but to Wilson, who only learned of Petty's concealed conflict 20 years after her conviction. Custodial status matters greatly. Without presentation by the parties of the issue in a case where custodial status made a difference, it's no wonder the Heck court did not have the full picture. Whether favorable termination should apply to non-custodial plaintiffs was not the question presented, much less answered in the Heck case. Yes, Casper, a footnote. We should also notice that the Heck court introduced its opinion by explaining that, quote, this case lies at the intersection of the two most fertile sources of federal court prisoner litigation. The Civil Rights Act of 1871, Rev Stat 1879, as amended 42 U.S.C. 1983, and the Federal Habeas Statute 28 U.S.C. 2254. This sentence shows that the court viewed the case in terms of the overlap between the two statutes, which of course has to do with prisoner litigation. Hi, FFS. After explaining that Pricer and Wolf did not answer the question at issue, the court also framed the question using the terminology that it had used in its previous opinions that had addressed the overlap between the statutes. Quote, the question posed by paragraph 1983 claims that do call into question the lawfulness of conviction or confinement remains open, end quote. The court situated its analysis in Heck within its long-running project to determine when a prisoner may use the 1983 and when he must use the 2254. The plurality ignores the court's framing of the issue when it argues that Heck holding is based only in tort law. The plurality proceeds as if Price's discussion of the overlap between 1983 and 2254 has been overruled. Not so. The Heck court only declined to follow Pricer in a narrow respect. It thought that Pricer's comment in dicta that damages should always be available under 1983 when the prisoner is not seeking release from prison was unreliable because it didn't account for the situation where a successful claim would imply the invalidity of a prisoner's conviction or confinement and would thus show that the prisoner should be released sooner. The broader points articulated in Pricer about the overlap between these two paragraphs in the prisoner context have not been abandoned by the court. The Heck court was clear that Heck was the latest in a line of cases that dealt with the overlap between these two, and the court was acutely focused on delineating when a prisoner could use 1983 instead of 2254. In contrast to what I explained thus far, the plurality misreads Heck to be based only on tort law. While I agree that tort law had a role in Heck's analysis, the plurality elevates tort law to be the sine qua non of Heck. What's this? I need to check that out. Without which, not. Okay. Respectfully, the plurality misunderstands Heck and distorts the court's precedents on the use of common law and analogs to interpret paragraph 1983 by extending the Heck bar without regard to the proper analogous tort. Tort law came into play in Heck because of the nature of paragraph 1983, which has long been recognized to, quote, create a species of tort liability. Because paragraph 1983 is not itself a source of substantive rights, but merely provides a method for vindicating federal rights elsewhere conferred. The court determined in Carey v. Piffus that a common law of torts is, quote, the appropriate starting point for the inquiry under 1983, because it implements the principle that a person should be compensated fairly for injuries caused by the violation of his legal rights. Only a motion to dismiss a 1983 claim, the threshold inquiry, requires courts to identify the specific constitutional right at issue. The next step is to, quote, determine the elements of and rules associated with an action seeking damages for its violation. It is at this second step that common law analogs play a role. They help a court determine what a plaintiff must plead in order to survive dismissal. When courts look for a common law analog, sometimes review of the common law will lead a court to adopt wholesale the rules that would apply in a suit involving the most analogous tort, but not always. Instead, the court has instructed that common law principles are meant to guide rather than control the definition of 1983 claims, serving more as a source of inspired examples than a prefabricated components. In fact, even if the common law does not recognize an analogous cause of action, courts must still adapt common law rules of damages to provide fair compensation for injuries caused by the deprivation of constitutional rights. As in this case, where a prosecutor who prosecuted the case at the same time was the law clerk for the judge he presented the case for, and then wrote the suggested rulings for the judge. Getting 2 paychecks and screwing every defendant that ever stood before him as a prosecutor over. But I guess he won cases. It's much easier to win cases if you both prosecute and write the rulings, you asshat. Because otherwise the purpose of 1983 would be defeated. Accordingly, the court has said no further the purpose of the rules governing compensation for injuries caused by the deprivation of constitutional rights should be tailored to the interest protected by the particular right in question. In sum, the Supreme Court has not viewed the common law as a straitjacket that restricts the reach of paragraph 1983, but as a starting point, a guide or source of inspired examples that helps courts create rules that further the purpose of 1983, to compensate a person injured by the violation of his legal rights. Respectfully, the plurality loses sight of this, making a threefold error. 1. Misreading Heck as adopting the elements of a specific common law tort as a blanket rule for a huge swath of 1983 claims. 2. Misusing common law analogs as the be-all, end-all rather than a starting point. And 3. Misinterpreting Heck's use of the common law to restrict access to paragraph 1983 to as many plaintiffs as possible. This approach is incompatible with the logic of carefully selecting a precise analog for a specific constitutional violation. And it is not what the court did in the Heck case. In the Heck case, the court used the common law tort of malicious prosecution as its starting point for 2 reasons. First, malicious prosecution provided the closest analogy to Heck's claim that the defendants had unlawfully and arbitrarily investigated and arrested him, knowingly destroyed exculpatory evidence, and caused illegal and unlawful evidence to be used at his trial. And second, it permits damages for confinement imposed pursuant to legal process. Favorable termination came into play only because it is an element of the common law tort of malicious prosecution. The element of a malicious prosecution claim are: 1. The suit or proceeding was instituted without any probable cause. 2. The motive in instituting the suit was malicious, which was often defined in this context as without probable cause and for a purpose other than bringing the defendant to justice. And 3. The prosecution terminated in the acquittal or discharge of the accused. The court adopted these elements, quote-unquote, wholesale for Roy Heck's claim. The plurality today recognizes that these elements were adopted wholesale, but then makes an unfounded leap to conclude that the favorable termination requirement must be met for any paragraph 1983 claim that seeks money damages for a tainted conviction. Malicious prosecution makes little sense as a common law analog for Wilson's claims. Nothing about her allegations resemble the elements of malicious prosecution. Wilson is not challenging the probable cause for her arrest, nor is she arguing that the motive in instituting her prosecution was malicious. She is instead bringing a procedural due process claim, asserting that a fundamental requirement of due process, a fair trial in a fair tribunal with a judge who is independent of the prosecution, was violated. Malicious prosecution with its favorable termination requirement is no analog, much less a close one. Karate Cat Mom, how was he not found out? I assume that the judges protected him. That's my assumption. The judges were perfectly happy with him prosecuting for them and then writing the decisions for them. So any of these judges who hasn't since passed away should be in prison, in my opinion. Forced to wear the robe in their jail cell. To sum up, the question presented in Heck was whether prisoners could bring a claim that would necessarily challenge their convictions under the 1983. The court was deeply concerned about the answer to that question because if the answer was yes, prisoners with outstanding criminal judgments could choose 1983 over 2254 and bring claims that, if successful, would require the prisoner's release, which is, quote, as close to the core of habeas corpus as an attack on the prisoner's conviction. To answer the presented question, the court had to determine the reach of paragraph 1983 because this is not a source of substantive rights. It looked to the common law as a starting point or guide and determined that malicious prosecution was the right fit for Heck's claims. Now, this is Texas, by the way. This is Texas. In what was clearly off-the-mark dicta, the court mused that favorable termination might apply more broadly. But dicta does not bind us. And as the next section will address, the court still hasn't resolved whether non-prisoners must prove favorable termination, a point the court has explicitly acknowledged. Regardless, malicious prosecution is a bad fit for Wilson's claims, and we should not try to shoehorn the favorable termination requirement where it does not fit. Amidst the careful passing of case law, it is important not to lose sight of what is at stake. The justification for stripping an explicitly conferred statutory cause of action to right constitutional wrongs. Comparing the justification for a custodial plaintiff to the one offered by the plurality is instructive. To the custodial litigant, who is told that habeas is the only path, the message is reasonable. A canonical tool of statutory construction, that the general gives way to the specific, requires that your presumptive 1983 cause of action give way to the habeas statute. By contrast, to the non-custodial litigant who is told that she is at the mercy of the state, the same state that nuked her constitutional rights, the message is unintelligible. Her statutorily conferred cause of action has been judicially negated to protect a set of values: comity, finality, and consistency. That 1983 is necessarily and always in opposition to. That those values apparently only become relevant when you have dual misfortune of the government violating your rights and then successfully hiding its dirty work only make the rationalization more dismaying. I'll now address the three post-Heck cases that the plurality believes underscore its broad tort-based conception of the favorable termination element, namely that it applies to all 1983 suits challenging a tainted conviction or sentence regardless of whether the plaintiff is in custody. With the greatest respect, the plurality is wrong on all three. When she talks about plurality here, she talks about the majority decision in this case that Ms. Wilson is not allowed to bring a civil suit against this corrupt prosecutor who moonlighted as a law clerk, who prosecuted her and wrote the decisions for the judge. The first is Edwards versus Balisock. Jerry Balisock was a prisoner who was punished for violating state prison rules. Part of that punishment was the, quote, deprivation of 30 days good time credit he had previously earned towards his release. He appealed within the prison's appeal system, but his appeal was rejected because he failed to comply with the procedural requirements. Balisock then filed a 1983 damages action alleging that the procedures used in his disciplinary proceeding violated his 14th Amendment due process rights. His allegations were, quote, similar to those alleged by the plaintiff in Heck. As he claimed, the hearing officer concealed exculpatory evidence and refused to ask certain questions of witnesses, all of which prevented Ballysock from presenting exculpatory evidence. Ballysock's claim posited that the procedures were wrong, but not necessarily that the result was. That said, Ballysock's challenge, if successful, would necessarily imply that 30 days of his confinement would be invalid, which would in turn imply the invalidity of his outstanding criminal judgment and mean that he'd be released sooner. Note that Ballysock was a prisoner at the time he brought his 1983 action, so just like in Heck, Edwards was a case where a prisoner with an outstanding criminal judgment was trying to use the 1983 to get out of prison sooner. And the court already made clear in Pricer that early release from prison is the domain of habeas. The plurality asserts that Ballysock was arguing that Heck's analogy to the malicious prosecution tort was a poor fit for Ballysock's purely procedural claim. But the court in Edwards never actually addressed those arguments. Instead, it just assumed, without analysis, that the favorable termination requirement applied. Indeed, the terms malicious prosecution, common law, and analog are never mentioned in the Edwards case. The better interpretation of Edwards is that Ballysock was a prisoner trying to get released sooner, who attempted to sidestep Pricer and Heck by not seeking restoration of his good time credits. But in the end, his claim looked just like Roy Heck's. If he succeeded, it would imply that his outstanding criminal judgment was invalid and he would need to be released earlier from prison. Wilson's case is fundamentally different from Edwards. She is not in prison, so her success would not require her to be released from prison earlier or at all. Next, the plurality, the majority decision in this case of the Fifth Circuit Appeals Court, claims that the court recently reaffirmed its interpretation of Heck in McDonough v. Smith. Edward McDonough was prosecuted twice based on what he alleged was fabricated evidence. His first trial ended in a mistrial, and his second ended in his acquittal on all charges. After his acquittal, McDonough brought a 1983 damages action asserting two claims: fabrication of evidence and malicious prosecution. The question presented in the case was whether McDonough's fabrication of evidence claims accrued at the time of his acquittal or at some point earlier. The court approached the case just as it does for all 1983 claims. It started by looking to the common law for an analogous tort to McDonough's fabrication of evidence claim. McDonough argued that the most analogous tort was malicious prosecution, and the court agreed. As we well know at this point, the common law tort of malicious prosecution contains favorable termination as an element, because Heck explains why favorable termination is both relevant and required for a claim analogous to malicious prosecution that would impugn a conviction. It is no surprise that the court concluded, quote, that rationale extends to an ongoing prosecution as well. What's more, the court was clearly focused on whether there could be accrual at some point earlier than acquittal, not after acquittal. Consequently, McDonough merely repeats Heck's conclusion that an acquittal causes the claim to accrue without discussion the question whether release from prison at the end of the sentence also does so. Even so, the plurality asserts McDonough resolved the question anyway because the court stated that the, quote, favorable termination requirement applies whenever a judgment in favor of the plaintiff would necessarily imply that his prior conviction or sentence was invalid. It takes the indefinite word whenever to mean that favorable termination applies regardless of custodial status. I would not understand the court to have resolved a question that it didn't tell us what that it didn't tell us it was answering, especially where the common law analog did have a favorable termination requirement. And the court was focused on whether a claim could accrue at a much earlier time than a completion of sentence. In fact, Justice Ginsburg, who had earlier said that Heck doesn't apply to non-custodial plaintiffs, joined the majority opinion in McDonough and did not express that he had changed her view. In sum, the plurality overreads McDonough on whether McDonough settled the reach of heck and enshrined the dicta of footnote 10. I agree with Judge Easterbrook. Certainly, McDonough did not do so, and accordingly, there are no quote-unquote instructions impossible to ignore. Finally, the plurality, the majority decision, points to Thompson v. Clark. Larry Thompson was charged with state charges that were later dismissed before trial. After his case was dismissed, Thompson brought a 1983 damages claim for Fourth Amendment malicious prosecution. He alleged that, quote, the police officers who initiated the criminal proceedings had maliciously prosecuted him without probable cause. Once again, the court looked to the elements of the most analogous tort, which here was malicious prosecution. Quote, the gravamen of the Fourth Amendment claim for malicious prosecution is the wrongful initiation of charges without probable cause, which is likewise the gravamen of the tort of malicious prosecution. Accordingly, the court held that in accord with the elements of the malicious prosecution tort, a Fourth Amendment claim under 1983 for malicious prosecution requires the plaintiffs to show a favorable termination of the underlying case against him. The rest of the court's opinion focused on, quote, fleshing out what a favorable termination entails. The plurality infers that because Thompson was not in custody, quote, it should be clear beyond cavil that the favorable termination element applies regardless of whether the 1983 claimant was, is, or never could be in custody. But the plurality misses a critical point. The reason the court required favorable termination in Thompson's case is because the analogous common law tort for Thompson's malicious prosecution claim was, unsurprisingly, malicious prosecution, which contains favorable termination as an element. The court never addressed Thompson's custodial status because it had no reason to. So Thompson could not have held that a favorable termination requirement applied to non-custodial plaintiffs writ large. Karate Cat Mom, her sentence was already over. So, and this is what this dissent of the majority decision tries to show. That the court overreached because it should not be an element in their denial that she didn't go all the way to have her conviction overturned. It shouldn't be a requirement, according to the dissent here. In sum, not one of the post-Heck cases supports the plurality's position. The plurality fails to track what questions were presented by the cases and under what circumstances. The Supreme Court has never addressed the application of favorable termination to plaintiffs like Wilson, who are not in custody and whose claims are not analogous to the common law tort of malicious prosecution. In fact, the court has acknowledged the ongoing debate and pointedly declined to resolve it, expressively stating in Mohammed v. Close that, quote, no case is no occasion to settle this case is no occasion to settle the issues. As none of these cases address the issue, I would take the justices at their word and accept their pronouncement that the issue remains unsettled. One last issue. The relevance of remedies beyond 1983. The plurality lists, quote, numerous avenues for pursuing favorable termination available to Wilson during an 8-year term of community supervision. The pluralities list is only accurate if one omits the pesky fact that Wilson could only have sought this remedy if she knew at that time that Petty has been moonlighting as both prosecutor and as de facto judge. Such an omission ignores the double horror of this case, that Wilson's due process rights were allegedly violated on a structural level, and that the violation was successfully hidden from Wilson and the public for 20 years. The plurality And the concurrence also stressed that Wilson still has various non-1983 avenues to challenge her tainted conviction. These points allied the solitary issue before us, whether heck even applies to non-custodial plaintiffs like Wilson. Whether Wilson might or might not be able to prove favorable termination outside of 1983 only matters if heck requires her to prove favorable termination in the first place. When Congress supplies a constitutionally valid rule of decision, federal courts must follow it. If Wilson is allowed to sue under 1983, then it matters not whether she might also have state remedies available to her. That's the whole point of paragraph 1983, to give those victimized by state officials a federal forum. The sole issues for us is whether heck applies to non-custodial plaintiffs, nothing else. The plurality and concurrence particularly focus on the availability of Texas state habeas. Texas' unique habeas statute specifies, quote, at the time the application is filed, the applicant must be or have been on community supervision. Not all state habeas statutes reach this far. In this circuit, for example, Mississippi statute only extend to all cases of illegal confinement or detention. Under the concurrence approach, the line between 1983 being available or not, quote, would depend on the vagaries of state law. If Wilson happened to live in another state in this circuit, her case might well turn out differently based on the reasoning in the concurrence. Also, and this cannot be overstated, to consider the existence of state remedies when determining the reach of 1983 is, respectfully, contrary to the historical record. It was precisely, quote, because Congress lacked confidence in state institutions, including state courts, that it explicitly gave federal courts jurisdiction over the new civil action. To then turn around, as the concurrence does, and say that there is no federal cause of action because Wilson could also pursue state remedies turns 1983 on its head. The concurrence asserts that if the plaintiff has the opportunity to obtain state relief, then she still has the chance to terminate her conviction. The concurrence argument, in effect, requires the plaintiff to avail herself of state court relief if the courthouse doors remain open. But this misses the point. The state court's labors, or lack thereof, have no bearing on access to paragraph 1983. One of the defining features of the 1983 is that plaintiffs don't have to go to state court first. The court has had, quote, no occasion to settle the issue, end quote, of whether heck reaches non-custodial plaintiffs, but it has declared it a, quote, settled rule that exhaustion of state remedies is not a prerequisite to an action under 42 U.S.C. 1983. Indeed, a 1983 provides, quote, individuals immediate access to the federal courts, notwithstanding any provision of state law to the contrary. Inexplicably, the plurality on concurrence point Wilson back to state court anyway. So this is an answer to Karate Cat Mom. The 1983 rule, it was specifically created so that people did not have to go through all the state shenanigans first. They should be able to go directly to federal, at least according to the dissent interpretation. It is especially bizarre to mandate state law exhaustion within the very criminal system and the, quote, very state officials, end quote, who failed Wilson for decades and whose hostility to those rights for fuck's sake, her injuries. Were she to return to state court, she would not even necessarily be provided counsel as a matter of course. Would any indigent defendant in Wilson's circumstance Someone stripped of core constitutional rights by a rigged judicial system have realistic hope for vindication. Forcing Wilson to seek relief from the same system that victimized her reduces 1983 to a mere paper promise. Our circuit has been on the wrong side of this fateful split for almost a quarter century. Today, we squander the opportunity to take, quote, the better view of Heck by holding that a former prisoner no longer in custody may bring a 1983 action establishing the unconstitutionality of a conviction or confinement without being bound to satisfy a favorable termination requirement. When Wilson learned that she had been victimized by Petty's mind-boggling conflict of interest, had she read 1983's sweeping textual command, she would have been heartened to take Congress at its word that she had a federal court remedy for what she had endured. It may be true that a federal court remedy isn't guaranteed for every constitutional violation, but the historical record shows that 1983 was enacted to provide one for a wide swath of violations that couldn't be entrusted to the protection by the state's courts. Today, the court unjustifiably limits that plain breadth of 1983, leaving plaintiffs like Wilson violated but not vindicated. There is no justification for applying Heck's favorable termination requirements so broadly. We are not bound by dicta in Heck's footnote 10. It makes little sense to apply a favorable termination rule to non-custodial plaintiffs. Non-custodial plaintiffs is people not in prison, whose claims are not analogous to the common law tort of malicious prosecution. No post-Heck precedent binds us, and the en banc court's justification collide head-on with the 1983 statute. When Judge Ginsburg disavowed Heck's footnoted musings on the ancillary question of non-custodial plaintiffs, she cited Justice Frankfurter's maxim that, quote, wisdom too often never comes, and so one ought not to react it merely because it comes late, end quote. Unfortunately for our circuit, and unfortunately for Wilson, wisdom remains a no-show. The only hope for wrong non-custodial plaintiffs like Irma Wilson is that the Supreme Court will at last confront the persistent circuit split, seize this court occasion to settle the issue, and vindicate a bedrock constitutional guarantee that, sadly, is even more tenuous in today's plea bargain age when the founding generation first enshrined it. Respectfully, yet emphatically, I dissent. So this was, let's see here, Fifth Circuit. The dissents are Judges Don R. Willett, joined by Judges King, Elrod, Graves, Higginson, and Douglas. So 1, 2, 3, 4, 5, 6 dissents. And let's see here. So it was more or less, I would assume, I don't remember exactly how many judges there are in the Fifth Circuit. I believe there are 18, so it's a 12-6 dissent. 12-6 majority decision. Karate Catmon, I would think the state wouldn't need habeas because they could fix it themselves, right? Yeah, but that's apparently not why this specific Rule 1983 was created by the Congress. It's created so just in case state courts cannot be trusted to vindicate some cases because of corrupt prosecution, there should be a federal remedy for people like Wilson. What are the differences between First and Fifth Circuits courts, etc.? They cover different states. Let's see, circuit courts. Circuit Appeals Court map. Okay, here it is. Let's see if we can, yeah. Here they are. Oops, I should show it to you. So here you have the different circuits. First circuit is up in Maine, then second, third, fourth. Fifth is down here, which we just read from. 6, 7, 8. Jesus Christ, 9 circuits is enormous. And then 11th, and then you have the DC and the Federal Circuit. So yeah. So basically, what this is about is this asshole in the middle there. Between 2001 and 2018 was both a prosecutor and a law clerk for several judges. So during daytime, he prosecuted the cases. And once the trial day was over, he went back into the back room and helped the judge write the decisions the judge should make in that case for almost 20 years. And it was discovered by pure chance because the district attorney, who was his boss, happened to come over more or less his paychecks for both prosecutor and a law clerk. And by the time that was discovered, this absolute monumental asshole had already retired. He screwed people over for almost 20 years. Amongst others, death penalty case. The guy who is currently on death row. And I don't really care if the people were guilty anyways. If we allow the government to do this, they will do it to everyone, regardless of your guilt. That is why we cannot allow this to happen. That is why cases against these people, these corrupt prosecutors, must be talked about so that either the courts will make a change or our lawmakers will make that change, or your lawmakers in this case. Whew, this was a rough one. Yeah, near blanket prosecutorial immunity. Whoever thought that was a good idea? Yeah, the prosecutors and the judges thought that was a good idea. Yeah. We need to get rid of that because the amount of corrupt prosecutors out there who get off scot-free are probably scarily staggering. Scarily. Oh. Yeah, that's definite ex parte conversation when the prosecutors is the law clerk who then talks to the judge. In every case, that human garbage ever prosecuted, he had a direct line to the judge. And not only a direct line, but just talking and giving arguments. He helped the judges write the decisions for the prosecutions he had. I did that for almost 20 years. All right, I think that is all I have for now. Oh, look at that. Quindarius Zachary is over $5,000 now in support of, so he can get a lawyer. That at least, though hopefully that money at least can get a lawyer out of bed and protect his rights. Does the law clerk have immunity? That's an interesting question, but him as a law clerk would have immunity? I don't know. But his dual shares might be that he has prosecutorial immunity as well. Yeah. And if, for instance, let's play with a thought. For instance, let's say the district attorney who in this case discovered it, revealed it. Imagine Barney Willis being in the same situation. Who many here believes she would have made public, hey, one of my assistant district attorneys has done this? I don't think so. But, this case infuriates me. There are so many cases that infuriates me, and there is not enough hours on. Yeah, there are not enough hours for me to cover them all, but I can cover some and bring a bit more attention to it. Now, I don't have much more, but I can send you off to somebody else. So you can have some fun. And over at Lego Law, Life and Libations, it's John Yates who is a guest, who hopefully you can have some fun watching him building Legos and being interviewed. So I will be sending you off to that one. But until then, thank you everybody for showing up. Thank you so much. Hope you have a great continued weekend, and hug your family. Unless your family is crap, then screw them and give your love to the people who deserves it. See you Monday for Young Thug Trial. All right. Bye-bye.
Gavel cracks, breaking backs, twist the facts.